Okay, can you see the slide? Hope so.
Yes.
Yes, okay. So yeah, today we are going to talk about intellectual property. We hope this is going to be useful for everyone in this room. We have worked at Strata with lots of startups and entrepreneurs that base the innovation heavily on intellectual property. And we think this is a very interesting topic especially for our audience, small companies, entrepreneurs, spin-offs, small deep tech startups. We're gonna have 3 speakers. I think we will change the order. Aracelia Tamariz will start as IP consultant. Then it will be followed by Rafael as innovation consultant, and then finally we will have also Linus Redblad, who will also give a short presentation. And in the end, I hope to have some time for Q&A so that we can all exchange questions and or concerns or any kind of topic that you want to raise. I will give just a short, very brief intro about Strata. What we do is we empower tech startups to build effective fundraising and go-to-market strategies. We work in 3 different areas, especially in innovation funding. We get funding for startups and for SMEs, mostly from European programs, such as the European Innovation Council, but we also work with some national programs, such as Innovate UK or Industries funding. We also help running innovation projects. This is what we call innovation management. Okay. And we, of course, work on IP strategy. So we help startups and small companies prepare IPs, especially focusing on using IP as a way not only to protect assets, but also to increase the appealing to investors and to public funding bodies. We also do valuation and investor matchmaking, and we work with some companies also in scaling the companies and getting into the international markets. Apart from Strata, well, these are some numbers of around Strata. We with EIC funding, as I've said, and we have got so far more than 70 million euro from European funding, almost 7 million euro in Green Deal funding, and we work in 14 countries now, I think. Apart from Strata, also Funding Trip collaborates with us, and we are also working closely with Funding Trip, which is a portal, a website that gives insights and information about funds and investors. Yeah, this is all from my side, so I think I will give the floor to Aracelia, who will start with her presentation. So I will stop sharing and allow you to share your screen as well.
Perfect. So I think you are seeing my slides now.
Yes.
Perfect. So just a little bit introduction about myself. So I am a pharmaceutical chemist by training, but early on I transitioned into innovation management and then did a postgraduate degree in IP law, European IP law, and that's where I specialize now, innovation and IP management. So today I want to talk about a little bit about the basics. So what is intellectual property? So intellectual property is the creations of the mind. So all the intangible assets that are created. So we have tangibles, houses, cars, but everything else could be chucked into intellectual property. Now, in intellectual property, we have several kinds. So we have literary and artistic works, symbols, names, and images in trade, inventions, designs, and also secrets. Those are a little bit of a special kind, but can also be put into that category. So a little bit about the cartoons. This author makes a lot of cartoons about IP and the issues that IP has at the moment. And I think that is a good representation that all the issues at the moment that we have with IP, that IP was not created to serve the inventors or the artistic works, but the other way. So the artistic works are not created to benefit the IP, but IP is created to benefit and protect the artistic works or inventions or designs, etc. So we must always take that into account. So now when it comes to what are the different types of IP rights, so IP rights could be divided into several categories. There is different opinions about what is what, but the general consensus is that you have industrial property. So that is the rights that have to do with more trade and companies, etc. And the artistic part of intellectual property, that is copyright. So within industrial property, we have the patents that we all know for inventions, trademarks for signs that are in trade, and trade secrets that are not, let's say, so official, but also are part of the industrial property knowledge. And in a little category, we have design rights. The design rights, depending on where you are at, they are a mix of basically everything. So if we see Europe, they are more a mix of copyright and trademark, more leaning into copyright. But for example, in the US, they actually have design patents. So they're more leaning toward the patent content. But in the end, design is where form meets utility. That's what we need to remember about designs. So now when it comes to the other types of work, so the first one that I want to cover, it's copyright. So copyright, as we may know, it's given to literary or artistic works, In the literary works, we also, in the modern time, that has come to, for example, code. Code, it's automatically given copyright protection. You don't have to apply for it as long as when you create it, that is given to you. Copyright has two sets of rights that are fairly agreed upon in the world. So you have the moral rights and the economic rights. So the moral rights are stemmed from the spirit of the author and the spirit of the work itself. For example, if a Jewish author makes a work of art and then some Nazis publish it, that would be against the moral and the spirit of the work of art. And now the economic rights are more the rights that we more know. That is the right to sell, to publish, to reproduce, and to enact, for example, and those can be sold. The moral rights cannot be sold, and there are always a property of the author. Now, these economic rights vary in the length of time and protection. The most that is given is 70 years, but the 70 years are after the author has died. So that is something to take into account. But again, it varies from country to country. And you don't need to apply for a copyright. You just have it automatically. So you don't actually have to pay fees to have that right given to you. The next thing that we're going to cover are trademarks. Now, trademarks are the signs and words for products and services in trade. So this is an extremely key important thing, that to be able to have protection under trademark, you have to use that product or service in trade. If you cannot justify that you have used it for trade, you will lose the protection that the trademark gives. And now the sign, the image, You can even trademark colors or, for example, sounds. They need to be distinctive. And that's why they're created, so you can distinct one product from another to have a distinctive creator, so you know you're buying from that person. In trademarks, you do need to register, indeed, to have a protection. But contrary, for example, in patents, you have classes. So, and an example of this is that you have, for example, Lotus, but you have Lotus cookies, and you have, for example, Lotus car. So they can coexist, but the registrations are from different classes and they cannot overlap. Again, this is an exclusive right, so you can only exploit that right. No one else has the right to use your sign or use your logo, etc. Now, as long as you use it and you prove that you're using it and pay the fees, obviously, there's no time that it will expire, that right. So basically, it's an infinite amount of time that you could use it. Now, they're not actual trademarks, but usually fall within the realm of trademarks are domain names and a geographical indication. So geographical indication is basically, for example, champagne that can only be produced in one region, or cheeses, for example, those are those types. But domain names are very special in terms of, for example, Lexus, that I told you there are two Lexus, Lotus. There are two Lotus coexisting, but there's only one domain name, Lexus.com. So that is a special that doesn't come with classes. But also, if you register a domain name and it can be proven that you did it to harm a trademark owner, that domain name could be unassigned to you. So there are also measures taken in place to help trademark owners to have domain names. The third and most prominent category for startups, it's the patents. Some call it the king of IP. That could be debated, but they're very, very strong IP rights. So something that we need to take into account about patents is that, one, they're a document, so you can read it. It's a very useful form of technology information and competitor information, but also it's a right. When you apply for it, it gives you a right, but not a right to do something. It is a negative right. It gives you a right that anyone can do for the length of your right, that is usually 20 years. No one can do or exploit that particular right. So a little bit of how the cartoon works is some people just patent, so someone else can infringe them and they go to court. So remember that having a patent does not give you the right to go to market or commercialize something. It's just that no one can use it. Again, as patents, you need to register for that protection. My colleague Rafael will talk a little bit more about that. And also, there's commonly two types of patents that are there. So the process and the product. So when we think about, for example, a car, well, that is way too much. For example, a pencil. So we could patent the pencil, so the shape, it has a little metal thing, the eraser on top, it's made of graphite. So that, if we patent that would be the pencil itself that is patented. But we could also patent, for example, the way that we make the round tooth or the little shape. So it's different things that can be patented. And for example, if we patent the process of making the pencil, no one can make the pencil in the same form. But if they do it in a different way and they arrive to a pencil, you're not infringing a patent. So that's something that we really should take into account. But for example, if we patent the product, they could use the same process as we do to making that. But if they arrive to a different product, then there's no problem. they're not infringing our patent.
Lost?
I think we've lost Aracelia. Yeah. Aracelia, are you there?
To reach the market, for example, that is an example. And the last right that I want to talk about, that it's the trade secrets. Trade secrets are any confidential information that you want to keep a secret. In this, compared to the other rights, you need to have a proactive protection. So it's not that you're granted automatically or the government will help you enforce it. Because once the information is made public, well, you lost completely your advantage. One example of this is, for example, Listerine. Listerine was a while ago a trade secret. They lost it, and now we have several brands. And so they lost, let's say, the secret sauce. Another one that has kept their trade secret and is the most common one, as an example, is Coca-Cola. The formula of Coca-Cola is a trade secret, and until now, it has kept that way, so they're safe. Now, there are certain procedures that you can that can help you enforce a trade secret, and basically is that you made a reasonable effort to protect that secret. For example, NDAs, confidentiality agreements, and there are several directives. For example, the Trade Secret Directive in the EU, the Trade Secret Act in the US. But again, you could go to court and have some payment, but the important thing, that is your IP, you already lost it. So that's very important. Again, no fees, and as long as you have it confidential, there is no limitation on how much you can keep that secret. So from my part, that's it, and I give now the floor to my colleague, Rafael.
Rafael,
Okay.
yeah, if you want, you can
Hello.
start and share your screen.
Absolutely. You see my screen now? Is it
Yes.
okay?
Yes,
Yeah.
we can see it.
Okay, perfect. Well, good afternoon, everybody. I'm Rafael Zabala. I'm an innovation consultant. I've been in innovation for more than 20 years, providing consultancy to companies and to public administrations. I have a long track record of courses in innovation and trainings in innovations, and I hope this afternoon I will get to transmit to you some of the concepts, the difficult or the heavy concepts that are behind intellectual property and specifically regarding patents. So I'm going to cover basics, concepts of industrial property to have a framework, and then I'm going to try to describe the patenting procedure, the four general patenting procedures and processes, and what are the elements that take part. Okay, so first of all, the definition of patent. A patent is a right, is a document that confirms an exclusive right for a period of 20 years to prevent third parties without holders' permission to manufacture, sell, use, import, or export the protected invention in the country where the patent has been applied for or it has been authorized. We're talking about inventions. Now, the law does not rule the rights over the inventions, but over the patents themselves. But what is behind the patent is an invention. Invention is not a juridical concept. The juridical concept are the patents. Another thing important is that holding a patent does not guarantee that we are not infringing the one of a third party. So together with obtaining the patent, we are obliged to assure that we have the freedom to operate. And this assuring is for ourselves in order not to be claimed or sued by a third party because they have discovered that we are commercializing or manufacturing something they have protected. Now, where are the authorities that give the patent rights here? Where are they? Well, actually, they are a help. They contribute, but they are vulnerable. That means whatever they say can be subject to somebody who claims the contract. Now, there are three conditions which are necessary, but they are not sufficient, referring to what I said earlier. These three conditions for an invention to be patentable are novelty. This means that it is not within the state of the art at global scale, and this is very important. This means that novelty is worldwide. Now, you might ask me, but how do you assure that? You cannot assure it. But you are provided a patent according to a certain search made that does not discover any other previous writing or dissemination paper that refers to your main claims or your novelty claims. Okay. Now, the second is that it has to have an inventive activity. It is not. It means that it is not an evident result of the state of the art to an expert in the field. This means that an invention has to be somehow tricky, or it has to have some magic behind, something that nobody could think possible without a certain imagination or a certain creativity behind. And that's what actually, like what Aracelia was saying before, that's what we are actually protecting when under intellectual rights. That is the creativity. Okay. Now, the third is that it's an industrial application. This means that it has to be aimed to the industry. It's not a one-time thing. It is something that can be repeatable and that can be and that can reach a wide variety of people, because that's part of the what we want to protect. We want to protect creative people providing good things to many. Okay. Now, so I would say novelty, inventive activity, and industrial application are three words that we have, three concepts that we have to have in mind always when we're talking about, when we think about patents. I would just tell you that to remember new inventive industry as a trick to remember what these three concepts, because they're slippy and slippery and sometimes we can forget them. Now, there are basically 4 patent procedures. Now, these patent procedures, let's say that 2 of them, the first 2 are normal national approaches, and the other 2 are simplified procedures under an international approach. What does this mean? This means that the focus of the first 2, national offices and international with priority dates, is country by country, while the others is a global search or a European search in the case of the European, in case of the European office procedure. So we have national offices. This means that we apply to one country. We have one application. There is one research process or one patent process. There is only one resolution. There will be a patent only in one country, and there there will be only one maintenance in one country. Now, if we want to go for international, we have to go country by country. This means that we will apply as many applications as countries apply. We will processes. There will be as many filing processes as countries where we want to get the protection, and we will have as many resolutions as countries, and the same for the maintenance. Now, there has been agreements between countries and to make this easier, and this is what the PCT, Patent Cooperation Treaty of 1970 came up with. Let's say it is a process where there is an international research by an agency, an international search authority that researches novelty, inventiveness, and application in the industry in the whole world. And then once that has passed, then we can apply for each of the countries where we want to get the protection. Something similar happens with the European office. In the European office, we apply through our national or directly through our national office or directly through the European Patent Office. We apply in applications. There's only one process. There's one resolution, and then we apply a validation. We get a validation in all the countries where we want to get the protection. So it is initially a general process, which is then validated by all the countries. Now, regarding the process, so I want to get to some of the concepts that we're always managing in the patent process. I talked earlier about we talked about priority date, international with priority date. What is priority date? The priority date is the date in which you filed your application. Why is this important? Because from the moment you file your application, there is a process in which one day you will be published. 18 months after you apply, it will be published, unless you withdraw your application. So this means that for anything that has been done, or any other patent, or any technology that has come afterwards, you are new. You can provide the novelty, or you have priority. You have actually the right over that, not from the previous ones. So the priority date is something tremendously, really important. So we make the application presentation in 10 days, more or less. Our application, let's say, is introduced into process. So that's where our priority date starts. And after that, there's a formal technical examination that only has to do with if you have paid the money, if the documents are legible, if they are understandable, and if you have followed the rules for to present the patent. If it has actually the form and everything's okay. So, and after that, there are from you have 15 months to request the state-of-the-art report, which is actually a state of the which it actually says whether it is new or it is inventive, right? So after this, and 3 months after your request, you will have your state-of-the-art report, and more or less this matches with the 18 months. This can match with the 18 months after which you are published. Now, if you are published from that moment on, you are visible. Your patent, your application is visible to everybody. So actually, for anybody who comes after, they will not be new because you have the priority date. Okay? So after that, so once it is published, your application can be subject to observations by third parties, which you can correct, or you can object, or you can rebut. And after that, in about 2 months, time that you are authorized, you can get the grant, or you might have it denied. Okay. So just to say that this is the most simple procedure of all. Okay. And this just to say that in this procedure, third-party observations are only informative for the national office to consider patentability. This means that it is your obligation to make the rebuttals. It is not it is not an obligation of the patent office. The other aspect is that applicant can make all the comments he considers to the SOR and to third parties, and can make changes to the claims. And the applicant has the right to withdraw in any moment. Now, this is the general procedure. This is being complicated. This can be getting more complicated, and we can go for something which is useful, which is the in-depth examination. It's the procedure is more or less the same, but after the state-of-the-art report is provided, the applicant can request a preliminary examination from the authorities, which is somehow an advice, or it provides more information regarding the potential of our patent to be actually granted. Okay, so these are the two basic ones. From then on, we can continue. For example, with the international procedure. The international procedure, what says is that from your priority date, you can apply in any country.
Rafael, try to end. You have 2 more minutes.
Two more? No, I'm
Okay.
gone. Okay. So you can apply to any country, and you can also apply for a Paris Conventional Treaty application, which is an international research. And after you have made the international research, you select the countries. So actually what you're having is 18 months more of time to decide in which countries you're going to patent, and you have 18 months more to decide let's say make modifications in your claims and your patent in order to have it ready for a good result. So this is more or less it. I brought in a lot of concepts, I know, but these are the concepts that we normally are using, and that's what we're using normally in Strata to make our FTOs. And this is the information that we're providing our companies, our clients, when they are deciding for their strategies. Okay, thank you.
Thank you, Rafael. So last but not least, we have also a guest speaker, Linus Wertbach. So Linus, he works as innovation advisor as well, and he's the founder of IP Screener. Linus, when you're ready, you can, if you want, you can share your screen, and you can. We are looking forward to hearing from you.
So I'm unmuted, but apparently my camera is not working, so I have just
we can
here.
We can hear you but not see you. Yeah, now we can see you.
Now it works better. Great. So hello everyone, great to be on board and on this session on IP and great presentations on the whole IP system and on the patent scenarios. That's great. I'm going to talk more about a specific case of creating and reviewing your innovation landscape within your company or project. So just before I start, my name is Linus. I've been working as innovation advisor for 20 years, starting as examiner at Swedish Patent Office, then as independent consultant and doing reviews on potential risks and opportunities with projects. If you're an IP, am I new? How new am I? What is my competition doing, and so on. And lately, I'm also developing a tool to enable also non-IP professionals to benefit from information in patents. So why is it important to talk about patent information? Now we talked about patent and applying for IP, but the information behind it, could that be of relevance? Yes, it can, of course. That's the rhetorical answer. And I'm going to share my screen here so you can see where we start. So I can do like this. So R&D IP, what map and what direction? So when you're starting a new project, basically you don't really know where you are and where you want to go. You have an idea of something, you want to go in a direction, you have identified the problem, you have reviewed a potential possibility to do something faster, easier, cheaper, and so on. But where should I go and what should I do? The basic scenario is that you just start doing it. And because you have an idea and you're going to do it, so you lock yourself into your room and you build something, and oh, here we go, you have your project ready. So I remember my own first project in school a long time ago. I wanted to create this fantastic new toothbrush with a toothpaste in the shaft. So I just went along and we had this study. I built the prototype and it worked nicely and so on. I was really proud. I won the prize in the class for the best invention. It was fantastic. I felt really like a superhero until my uncle gave me this for a Christmas present. Exactly the same solution. Even better, because this was a cartridge you could exchange, so it was already there. And I was like going from feeling a superhero to just stupid in a couple of microseconds. Why did I spend one term building something that already existed and even a better solution? So this is what I'm a little bit going to elaborate around, the importance of being aware of where you are and what the direction to take. So the industry. What is about the general industry and how do we do innovation? They must be doing better than me, hopefully. But actually, the answer is a little bit intriguing. More than half of all the application worldwide. These are US numbers, but this is the same situation in the whole world. It doesn't matter if you're a big company, small company, if you're educated or non-educated, high tech, low tech, deep tech. You have the same situation. About half of the applications are rejected, not because they are not working or because they are lacking inventive step. As we come back to Raphael said, they are not enough invention. They're partly or fully overlapping with existing solutions. And the only in US, to give you some indication on the value spent, is the $200 billion per year. And it's the same in Europe and the same in Asia. So about $600 billion spent on time, money, and brains on building, just recreating things that already were there. So why is this happening? Well, we talked a little bit of this earlier. And the main challenge here is that 80% of all technology is hidden in patent. So and just for give you reference, 30%, if you Google something, it's about 30%. So that means that the sole major source of information for any innovation project is in patent information. But it's complicated stuff because it's legal documents describing a technical solution. They are hidden under surface. So if you're sitting in your boat and you do some Googling, you're going to see, and it looks like a little small island or maybe a seagull swimming on the sea. But if you put your head under the water and put on your snorkeling and IP equipment, you're going to see it's actually an iceberg. And if you head straight ahead, you're going to crash. And this is what's happened in so many projects because they are not either not aware or ignoring the IP information. It's complex to search, and you need very often assistance to interpret what's there. But even though it's very important, I mean, 80% is hidden there, and 90% of it is free to use because it's not in force anymore. So you see, this is also a way of speeding up innovation. So by assessing this data and the aggregated results from it, you drive smarter R&D because you can take on from other solutions if they're free to use. Means you're going to be speedier, and you can avoid reinventing, putting time on reinventing solutions that already exist. So you can focus the whole of your brain resources and time on your specific solution and feature. And then also you can identify competitors to avoid, navigate better. We talked about freedom to operate. We can get the first insight very early on to not build the track on, so you have to re-engineer later on. You can actually navigate maybe a little bit earlier, or take solutions where you're able to work together with the partner, so you have that ready, so you don't just crash into something and then have to do the homework and re-engineer. And of course, finally analyze trends and market, because you're going to see what has been done, what is going on. Is this something that is saturating, trending, declining? Where is the activity going on in the world, by who, and when? So that this is just a few examples of how IP information could be used. So coming back to the R&D process then. So you've probably seen this funnel in how it works. You want a lot of ideas in the beginning, you do the ideation, so then it's about finding the right projects, and then you want to nurture and select the right projects to do the projects right. That means cost traction, production, the management. You want to look at resources, specific solutions, adaptation for market, and so on, and do the right package for the market and the client. And then finally, you're rolling it out, and you can have a sustainable process and keep going on with the project until you retire it, and you hopefully have other projects in your pipeline to get going. But coming back to the scenario of a reinvention, not very often you tend out to understand where you are in the rollout scenario. So that's where you are when you go to knockouts, either from a patent application, or you have an investment going on, or maybe some other kind of partnership going in, and a big company will see you out. And then a study from UCLA, just to give you distribution of where the money goes and time goes and the resources goes, is these are US numbers, but you see that from an average innovation project in US, it's about $616,000, and 604,000 of those are spent normally well before grant. That means that almost 99% of the costs are already taken when you understand you have reinvented the wheel, you had your team and your resources on the wrong project. So, and in US numbers for big corporates is about 300,000. So it's half, a little bit more in between in the Asian region. And of course, in startup, it's not as much, but the interesting part here is the distribution. When you discover normally that you have in rollout, the most of your resources already spent, and you don't want to do that. You want to spend it right. So by doing an analysis in the IP domain and the patent information, you're able to, during ideation preferably, you're going to spend 90% of your time, of your team, and of your money more wisely in the right project. So this is the main takeaway I would like to sort of teach, that during ideation, make sure you do a first check on what's out there. It doesn't have to be perfect. It just has to be good enough, and that you at least start to understand where you are, because you don't really want to run blindly and get the landscape when you're doing the rollout to understand that you're actually jumped off the cliff and you don't really have a project and you're going to sort of crash. So start doing it as early on as possible, and preferably during your work all the time, nurturing and find more information. But coming at the patents are difficult documents to read. That's of course a challenge, and we see also the number of patents are increasing rapidly. Today we have 79 million families and about 170 million documents worldwide. So it's a difficult source of information, and documents there are many documents, and they are often long, and they are written in a way that's not really easy to maybe digest if you're not trained to it. It's not a book you read from A to Z, so to speak. It's not a thriller. So you really have to sort of be prepared how to use it. And this is a bit of an overload for regular people. So what I'm coming from, what I'm trying to do is using AI to facilitate the assisting of exploring this information. And and just to teach you a bit, in a pattern document, it's not a book A to Z. I said it. It's a pile of segments. So first you want to find the right document. And then you want the document to be segmented into relevant parts. So if you have several hundreds and even thousands of pages, you want that to be put into parts. Because then you see that actually some slices are very relevant, the red ones, and some slices are completely irrelevant, the green ones, because the area is talking about other stuff. And you want to identify those very early on. And here comes the AI tools into play, which are around the market. And there are different approaches and different aspects. And then thirdly, you want to also, I'm going to close this one, to identify also the suggested interpretation, why it's relevant or not. Because and so try to remember that these documents are not to read. You identify the right parts, and there we're going to go to identify where sort of how that maps to your information, because it could be one page, page 700. Yeah.
Linus, you have 1-2 minutes more.
Yeah, I'm almost ready. So thanks. So this is a way of how it could look like so how we approached it, that the tool zooms into the right area right away. You're going to be highlighting in colors where you're supposedly best start reading. So this is one way of doing it. And this is also something we have a freemium version actually you can try use on your own. You don't have to that could be a good way to start to see how go ahead. So my challenge to you, what about your ideas? Have you really tried them out yet? We have a solution in place, you can try it out, but I also list here 3 free sources which are really great. The SPASnet, hosted by the European Patent Office, the Patent Scope, hosted by the WIPO, and the Google Patents, of course. Just to note that Google Patents, they will track what you search for. So if it's a really, really interesting idea, maybe you should use the other tools or go to an attorney. Thanks for listening.
Thank you, Linus. Thank you for your presentation. Thank you again, Rafael and Aracelia. I now want to give time to potential questions from the audience. Anyone has any question? Maybe I can start. Otherwise, with some questions. So I was thinking like about the different procedures that Rafael presented. What is the most cost-effective one for a small company or a startup?
Well, I would say the most cost-effective one is the national patent. I mean, you go first to your country and see you are able to develop a patent to get it granted. That will provide you a lot of information, and the cost of a patent without the preliminary examination can be in the range of 800 euros, while with the preliminary examination it costs 1,200. Then from then on, if you go to the international, you would go country by country, adding 800 euros each. But a big part of the cost is also the consultancy costs in writing down the claims and writing down the patent in each country. That requires being translated. Okay. Let's say maybe cost effective, but the cheapest is go country by country. But if you have if you really believe in your innovation, you should go for international or to have wider coverage. And in that case, a very good solution is the PCT. Especially because although it can be more expensive, it it provides you time. It gives you time to perform better, to introduce the changes required, and remember that that the search is done by an international company. So, or international, it's an international search made by an authorized or a well-experienced agency. So you have more guarantees when when we refer to the novelty and the inventive concepts of your patent. Yes.
Okay, thank you. Anyone else wants to make questions?
I can maybe add on that also that very often design rights are sort of forgotten about. So if you do have a reduced budget and you have you can actually have really good protection. That's a very cost-efficient solution as well, especially if you're working in software, because you can protect your interface and your UX via design rights as well. So that's sort of a not a good thing to start with as well, not to forget.
Okay, but by the way, that was going to be my second question. I'm really curious about software. I talk to many startups, especially startups every week. Sometimes they tell me, no, we are doing software, we cannot patent. And at the same time, I'm meeting other startups who are doing software and they tell me, yeah, we have 2-3 patents. So I think there's a lot of confusion around software. I'm really curious, what do you, any of you, what do you think about it?
Yeah, well, I was actually examiner for software inventions at the time. So basically, I would say today, maybe Ericsson, maybe 95% of the inventions are software related, but you don't express it as a software. So it's how you write about it. It's problematic that the rule from 76 says that software as such is not possible to protect. You have to embed it somewhere, but if you describe it in a method, you can still have protection for it. It's about tactics. And also, if you're really important to do it, you should probably start off with US, where you have much easier way to protect it and much more sort of open to those kind of solutions, and where Europe is very restricted. So we have seen the many solutions we actually start off in the US with those kinds of inventions. And but you should not rely on your copyright there, because there is basically no known case where anyone has done copyright infringement. Maybe trade secrets theft, but the copyright infringement is more or less impossible. You take a code and you decompile it and into a new language, you go new invention or new copyright. So yeah.
Okay.
Yeah. So if it's really important, you should try it, but maybe not starting in Europe. In that case. That's maybe Rafael has a different experience.
No, absolutely the same. I mean, the thing is that in the United States you can patent straightforward. You can patent code, while in Europe, no. Under Europe, it would go under the copyright law. But yes, I think you touched the point. The thing is that a software can be part of your claim regarding a methodology or a product itself. So it's embedded in your process or your product. Yeah.
Something that I would like to add is that if your product or your invention is mostly software, also I would like to ask, for example, the company, does it make sense to patent? Because in 18 months, 2 years, even 1 year, even 6 months, would that be relevant? Because it moves so fast. So is that effective? Is that an effective way to protect? Or it will be just money and eventually won't serve any purpose, because by the time something comes out of it, you will just move on and have a new thing. So that's also something to take into account, I would ask.
Okay, so we have run out of time now. So I think we will leave it here. Thank you again, Aracelia, Rafael, Linus, everyone who has attended. Thank you very much for your time. And yeah, we'll be in touch. Thank you.
Thanks
Thank
very
you.
much, David. Thank you. Great
Bye.
presentations.
Bye-bye.